This is on for presentation of order as well as an initial guardian plan review. Let's see, we have Ms. McLean, we have Amy Turnbull, we have Jared Williamson. Anyone else appearing on that matter? Hearing none, I will turn this over first to Ms. McLean.
Thank you very much, Your Honor. My office did communicate with Ms. Turnbull, and I understand that she has received fees.
You're going in and out. Ms. McLean, I'm having a hard time hearing you.
I'm sorry. Is that better?
Yeah.
I'll slow down. I understood that Ms. Turnbull had already received fees from both parties and packets and has commenced her investigation. And if that's accurate, then the order provides that her final report would be due on November 12th and that we have a final review hearing scheduled for November 26th at 9 a.m.
All right. So, Ms. Turnbull, can you give me an idea of where things are at for you?
Yes, both parties have paid their fees. I have met with all of the parties. I've done a home visit for Ms. Toll. I had a Zoom visit yesterday with Mr. Williamson, and we're in the process of scheduling a home visit for him. So everything's in motion.
Okay. So I'll get to you in just a minute, Mr. Williamson. So I have the proposed order, and I went through that. It appears to reflect what the ruling is. I didn't see any objections that had been filed. So, Mr. Williamson, is there anything you wanted to add at this point?
I guess my question is the child support a final order or a temporary order?
This is all temporary.
Okay, and I guess I would just ask why I don't receive the deviation for my other biological child that lives with me full time. That would be my only question.
Right, Ms. McLean?
The court ordered that he would receive one deviation rather than two. That was part of the court's ruling. So we made that argument as to whether or not deviation was appropriate, and Your Honor allowed for a deviation for one child. My understanding is the other child is the stepchild.
No, that's not accurate. I have two other biological children and another stepchild.
So if the court feels that the deviation would leave the child that you're paying support for at such an amount that would not be appropriate, that the court would go ahead and deny the deviation. It's not something that's automatically provided or given.
Okay.
All right. So with that understanding, you may not agree with the how the court ruled, but do you believe or agree that the proposed orders reflect what the court ruled, and I can put approved via Zoom?
Yes.
All right. So with that, and Ms. Looney had previously signed off as to language that they required, and so I have signed the orders.
Thank you.
Thank you. I see we have Ms. Powers. Do we have Devin Lockwood? Not hearing. Ms. Powers, did you send orders? Maybe that's what I've got here.
We did send orders over. We also filed the proposed orders and mailed them to Mr. Lockwood on August 22nd.
Okay. I think that's what I have here.
And I've received no objections from Mr. Lockwood.
Okay. So the court did not receive any objections. He has not responded here today. And so with that, I will be signing off on the orders. All right, so I have signed off on the temporary family law order, parenting plan, and the order appointing guardian ad litem. Anything further, Ms. Powers?
Nope, that's all. Thank you.
All right, thank you. I see we have Ms. Bliss. Do we have Deanna Raquel? Not quite sure.
What number are we?
8.
9.
No response. That Ms.
And Judge, I did send over final orders in this matter. I had made several attempts to contact Miss Rackick prior to today's hearing, so it was my understanding that those were agreed. This was her motion, and my client, after several months, is agreeing to her motion. So those final orders of invalidity should be entered today.
All right, I've signed off on the findings and conclusions about its marriage and the other annulment decree as well.
Very good. Thank you, Judge.
Morning, Your Honor. Jim Sansone appearing for the respondent.
Fred Anagnosio on behalf of Christopher Crocker.
Casey Looney on behalf of the state, Your Honor.
Twyla Corey, guardian ad litem.
Go ahead.
Thank you, Your Honor. This is the state's motion for a temporary child support order. We are requesting that order be entered because there's been a change in the TANF benefits for the children. Now that they are placed with the father, Mr. Crocker, they are receiving TANF benefits through his home. So we're asking for an order to be put in place requiring Ms. Acevedo to make payments for child support for both children. We did impute income for both parents at the allowable amount for TANF under the statute, which is 32 hours per week at the minimum wage, which is currently $16.28. That gives both parents a net monthly income of $2,035. We are asking that the transfer payment of $466 from Ms. Acevedo to Mr. Crocker for both children begins June of 2024. That is when TANF benefits began in the father's home for the children.
Mr. Anagnostou?
I have no objection, Your Honor.
Okay. Mr. Sansone?
Good morning, Your Honor. My client has instructed me to inform the court she isn't in agreement with the wage imputation. She says she hasn't been in the workforce for some time. I explained to her what was going on and why, and I told her I would put that on the record, but I'm prepared to submit.
Okay. All right. Based on the files and record, I will sign off on the documents proposed by the state. First, I've signed off on the worksheet. And then, so Mr. Sansone, are you okay to put approved via Zoom?
Yes, Your Honor, that's fine.
And Your Honor, the state would just request, we did originally request on our order the start date be September. We would just ask that be changed to June if Your Honor can interlineate. The Division of Child Support was working on an administrative order.
Just a second, let me get this filled out first and then I'll get back to that. And Mr. Anagnostou, you okay to put approved via Zoom?
I am, Your Honor. Thank you.
Okay, so where am I at that?
Your Honor, on page 4 in section 11, if we can just change the start date there to June 1 rather than September. Division of Child Support had anticipated an administrative order in place to cover the TANF period prior to next month, but was unable to serve the mother with their documents. So we're just asking that our order cover the entire TANF period.
Okay. Any objections from anyone?
No objection.
Okay. So I have made that change.
Thank you, Your Honor.
All right, I assign the orders.
Thank you.
Thank you.
Thank the court.
Ms. Copeland. All right. So this was set over a substantial amount of time. I did not see any additional documents. I didn't know what was going on, what the plan is, or just what we're going to be doing here today.
Your Honor, we're following up on, this was originally a motion for order to appear and show cause for contempt on the basis that the personal representative of the estate had not fulfilled the terms of the divorce decree. But the remaining issue, there were two issues at the time the motion was filed. One of the two debts that was ordered to be paid as part of the divorce has been paid. The other one is still outstanding. It's a debt that's in the name of both my client and the decedent. My client received notice that the account was in default and repossession of the secured property, which was a motorhome, was in process. So her credit is being adversely affected by this. And I don't have any updates in terms of what's happening with that. As far as I know, the debt is still outstanding and unsatisfied.
Mr. Andrews?
Yes, Your Honor. I'm going to renew the point that I made last time, which is that in Washington State, contempt is not an available remedy to enforce a property settlement. The proper venue for a creditor's claim is pursuant to RCW 11.40 in the probate court. There are creditors' claims. They are being worked through. No one has been favored. HAPO Credit Union has a creditor's claim in. The counsel's client has one in as well. A bookkeeper has one in. A former attorney has one in. And the personal administrator can't distribute money without order of the court anyway, so he can't favor himself because he does not have non-intervention powers, because this is an intestate estate. So any concerns that a creditor has cannot be addressed by contempt from a prior family law matter. It's just not available in Washington State. So properly, counsel, if she wants to do so, can take this matter to Clark County, to the probate court, and pursue that creditor's claim and any kind of relief that she would like under RCW 11.40.
Ms. Long?
Well, my understanding of the contempt process is that it can be used to enforce property settlements that are entered by this court. I'm here today because my client is concerned about this debt. In her declaration, she indicates that her belief, at least at the time the declaration was filed, was that the executor was living in it, and she just doesn't want to be. She's in a different position than the other creditors because her name is attached to this debt. It's a fairly large debt. I think it's around $38,000, and if it's not satisfied by the estate, then she's personally liable for it. So that's why she's asked me to come here today to try to get it resolved.
So, Your Honor, all these remedies lie in 11.40. A general money judgment or a property settlement simply cannot be enforced by contempt. Only spousal support.
Counsel, you've made your, I heard your argument. So, Ms. Long, I would agree in regard to what counsel has indicated. I understand where she's at, and that even if there was contempt, I can't find a willful and an intentional violation of the court order, which is what it would take for a contempt. Just non-payment by itself is not sufficient. And so even if contempt was an option, the court couldn't make that finding. So at this point, the court believes that the only real remedy that she has at this time is to pursue it through the estate, as has been indicated. And if she believes she has priority somehow, then that has to be handled through the estate, not through this matter. So I can understand where she's at and then the frustration with that, and we see it on many matters, but at this point, the court would deny the motion.
No, Your Honor, at the last hearing, because it was pointed out in advance of the last hearing, and again before this one, that contempt was not an available remedy. At the last hearing, we had asked for $1,935 for having to appear in court that first time, but we're here a second time. So I would renew the request for attorney fees and costs simply on the basis that this is a remedy that just was never available. And this was an expense that never should have been borne. This proceeding should have been in the probate court, and that was pointed out well in advance of the first hearing. So I would ask for an award of attorney fees and costs for that misstep in bringing this in the wrong court, under the wrong cause, under the wrong statute.
Ms. Long?
I understand counsel's argument. I think it puts form over substance. I mean, the bottom line is that my client is owed this debt, and whether she pursued it in this court or the court in Clark County, the fact remains that it hasn't been taken care of and it remains unpaid. So I don't think, clearly it would not have made a difference whether she brought it in this court or whether she brought it in the probate court.
So at this point, the court does see where Mr. Andrews is at in the request. The court's not going to grant because I don't think there was a bad intent in what was being pursued. And so With that, the court will go ahead and grant $1,000 in attorney's fees for the necessity of having to respond to this matter. And I'm not going to put a deadline as at this point. The matter will be addressed in the manner it needs to as far as the estate. But I'll grant $1,000 in a judgment.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Counsel, just so you know, I've reviewed the files, reviewed the documents, and just so you are aware of that, I see that we are on for 1, temporary orders, and 2, a show cause order for contempt. So with that, we have Mr. Anderson present. Do we have Mr. Trotter?
I saw him, Your Honor.
This is Erica Turner. Mr. Trotter had to step out. He sent you a message. He had to step out for another hearing.
Oh.
Okay. Unfortunately, okay, I'm going to take a quick break. One, we need Mr. Trotter, obviously. So I'll be back at 10:20.
Right. Thank you, Your Honor.
8, we have Mr. Trotter. Do we have Mr. Anderson?
You do, Your Honor.
Okay.
Mr. Day, my client is here as well. Thank you. I believe the guardian ad litem, Ms. Corey, is present.
Okay. All right. So again, I have reviewed the file, and so with that, counsel, go ahead with your motion.
Thank you very much, Your Honor. Ken Anderson on behalf of Donovan Day. I would just note that my opposing counsel has filed an objection, and I guess I'm wondering if the court wanted to hear that first, or if we could just, I'd be happy to proceed, certainly.
Are we talking about the objection that's filed August 8?
Yes, Your Honor. And I guess briefly there, just to respond, we do believe that there has been a significant change in circumstances, as I outlined in my response to the objection. The mother petitioner has violated several court orders here. The conditions of that the child is in, that this little family is living in, are absolutely filthy, it sounds like. Secondly, the objection was based on the fact that this court had previously denied the adoption of the GAL report, and I was not present at that hearing several months ago, nearly a year ago, but my review of the audio recording and of the clerk's minutes indicate that the court clearly did not deny it with prejudice, that it was just the court did not feel apparently that it was fully briefed, and that's what we wanted to do today. Finally, the drug tests, Your Honor, those just haven't been fulfilled. So then moving forward, if the court would permit me, I'd like to start with the motion for contempt here. And going to the drug tests, the mother has not provided my client with the opportunity of a collateral input into this drug test. She submitted a drug evaluation that does not fulfill the court order. And frankly, it appears she's trying to pull a fast one over. The mother has moved with the child several times, and for that reason, this matter is caught up in a relocation act of sorts. My client is not even provided with the opportunity to object to the relocation because his daughter, is being moved around rather willy-nilly.
Okay, so I'm going to stop everything. Originally, I was looking at the wrong thing when I gave the date of the objection. So just so it's clear on the objection, I just looked at it as essentially a response. So I'm not looking at hearing that first. I understand the issue and the concern. So if you want to do the contempts first, that's fine. Let's go down each of the contempts. And I can address those as far as the contempts first. So let's address the motion for contempt.
Thank you very much, Your Honor. Your Honor, as we've indicated, it appears that the mother and child have moved 4 times, which is in clear violation of the temporary order in place that requires that notice be given. It's simply not happening. There is interference with the vacation dates. It's clear that in the temporary plan, my client was to submit his dates by May 1st, which he did. The mother just ignores those and does what she wants. She starts reserving dates going into the Christmas time. She withheld the child then on July 5th. That's in our Exhibit 1. There was a submittal of a letter in our original motion, and apparently that was kicked back by the clerk's office. So on the unilateral decision makings, apparently our exhibit did not make it in, Your Honor. But at any rate, the allegations that we make about the unilateral decisions, the extracurricular activities, those aren't denied. She just tries to explain them away. The mother is making unilateral decisions on where the child's going to live, where she's going to go to school, what she's going to do for extracurricular. She turns to my client only to inform him when he's going to pay, but she doesn't inform the father what is going on here. The out of state, the mother just denies that it's a court order. And on page 2 of the temporary family law order, in paragraph 4, it clearly states that both parties cannot remove the child from the state of Washington. So the mother's response here is that, no, it's not a court order. And by the way, the dates were screwy. Apparently there was a Scrivener's error. January was written when it was supposed to be July. The daughter talks about the Long Bridge, which is, as soon as I saw the reference, I thought of the Astoria Bridge, because that's certainly what it is. There are some allegations that there were sleepovers in Rainier, Oregon. And then we have the sighting, I guess I'll put it, of a family friend when they were in Oregon, until the mother realized, or the older sister realized, oh, this is not supposed to be happening. The failure to get a drug test, Your Honor, given the GAL's report here and the continued movement of the mother with the child, when the GAL said she's very concerned and found this continuous moving to be quite alarming. The mother doesn't seem to appreciate the freedom that she had. And I want to have that in the past tense. She is not free to violate court orders. She's to follow them. And the fact that we have to come to court and say, please, Ms. Turner, follow the order. We should be compensated with attorney's fees as per statute. We are asking that attorney's fees be awarded. It's a little bit mixed up because we have both this contempt motion and our motion to modify the temporary family law order. There are, we believe that there are separate funds being held in the trust account at Mr. Trotter's office. We are asking the court to order that $5,000 be removed from that trust account in payment for the attorney's fees for this contempt motion. I just want to look over my notes briefly here, Your Honor. Yeah, there are photos of being at the Seaside Aquarium on Facebook. As soon as those happened, the mother makes allegations that my client is stalking her. That's just not happening, Your Honor. My client is trying to protect his daughter and find out where his daughter is. And what's happening, he's finding out that his daughter is being taken out of state in violation of a court order. Yeah, Your Honor, would the court, I guess I would defer to the court right now as to whether Mr. Trotter respond to the contempt, and then we'll move on to the motion to modify.
Yes, I'd like to address the contempt matter first. Mr. Trotter?
Oh, yes. So my client is not in contempt. This, as you know, Your Honor, this is a highly contested case, and it's gone on prior to both Mr. Anderson and my time on the case. It's my belief and assertion, my client's belief, that the opposing party is just not happy with the judge's ruling at the time in May of 2023. And he makes that clear in his presentation just recently. Concerning the drug test, it's my understanding that a drug test was performed and that information is provided under seal. Mother has not moved with the child. The mother was homeless at a time. And then, as indicated in the pleadings, the mother found stable housing as of February 4th, 2024. So the freedom that Mr. Anderson references, I think my client would disagree that being homeless is not being free necessarily. So I'd just like to point that out. As for relocation, and my client not have provided the opposing party with notice of that, there has been no relocation, and so therefore there'd be no notice required. My client is not interfering with vacation time as part of the original parenting plan. As you know, it requires or provided for 2 weeks uninterrupted time. My client provided notice well in advance. In fact, in February of 2024, my client provided notice to the opposing party. He did not respond until April. So she is abiding by the request of the court. And just because she provided early notice does not make her in contempt. My client has not withheld the children. And with respect to separate funds, release of separate funds to out of the that our firm is holding money in the trust as separate funds is a matter or issue that has not yet been decided by this court. So therefore, no money should be classified as separate funds. As far as being in Oregon, it's unclear to me whether or not the statute provides, and I'm not saying my client did, but the statute provides that no visitation to Oregon is permitted. It's unclear to me whether that's what that means, is that no visitation to Oregon be permitted. So I'm not saying that she did, but if she did, then that would be a question that I have for the court. So I think I'll just stop there on the motion for contempt. Thank you, Your Honor.
Mr. Anderson?
Your Honor, the vacation issue is a bit problematic in that the temporary orders say that my client is to submit his dates. It's because his time, I guess, I don't know why, but his time is much more limited than the mother's under the temporary plan. It does not provide for the mother, and it certainly doesn't provide for her to go into the holiday time. My client wanted 2 uninterrupted weeks as the order provided. He submitted them. It doesn't say the mother gets to object, even if she asked for them first. She doesn't have a job other than driving Uber. And that's why my clients needed to request the dates. So, Your Honor, he has been paying his child support. And whether the funds are characterized as his separate or community, we're asking the court to permit Mr. Trotter's office to release those in compensation for bringing this contempt motion. Thank you.
If I may, Your Honor.
No.
Okay.
So in regard to just the contempt matter, first going through the mother moving without notice, the court does not find a willful and intentional violation has been shown, but speculation at best as to dates and times. So the court does not find contempt on that issue. As to extracurricular activities, the court does find there is a willful and intentional violation where the child is enrolled in an extracurricular activity. Even if the father is not required to pay for it, it doesn't matter. It is joint decision-making, and it still requires joint decision-making of whether or not the child is going to be in that activity. As to enrolling the child into school, there is no showing of a willful and intentional violation as the child was maintained in the school and there was to be no change in schools. Respondent shall provide proof of her payment within 7 days and documentation of what the father's portion shall be. The father is to pay within 7 days of receipt. As to the vacation time process, the court cannot find a willful and intentional violation as the language is vague on the process. To clarify the parenting plan, the father shall submit his requested time by April 1 and the mother will follow with her requested time by May 1. So the father will make the requested time first, again, by April 1. And then after the father has done that, then the mother is to provide hers by May 1. As to taking the child out of state, the court looked at the prior court order parenting plan. And again, the court does not find a willful and intentional violation of the court order of May 2nd, 23. Although the box is marked one place that they are not to go out of state, under paragraph 4, there is a reference to the father having visits in Portland or Vancouver. So there's conflicting language in this parenting plan. It looks like it was written in and added later, but they didn't correct the other language. So the intent likely wasn't for that box to be marked as it was for both parties. So she's in contempt, and he's had the child in Portland. He's in contempt as well, but I'm not finding that. It's confusing. So the court is not. Per order of May 2nd, 2024, paragraph 14, both parents are to install Facebook Kids Messenger and all the child contact via the app between parents and child. Father says mother blocked him, but there is no showing he was blocked from the app to talk to the daughter. So there is no finding of contempt. So the court did find contempt as to the joint decision-making, which is important. It's in the order. It needs to be done. The mother does not have the right to make unilateral decisions, whatever it may be. And so it is important that the consultation be made. And for that, the court will order $150 in regard to civil penalty, and then $1,000 in attorney's fees for the necessity of having to bring this motion before the court. Those $1,000 as far as getting paid, the court's not real clear on this $5,000 and what it is or where it is. So I'm going to reserve. You can have a judgment for the $1,000 and then figure out from there what needs to happen. Bottom line, in regard to this case, from everything I've seen, it needs to get to trial. The parties can't agree, then go to trial and get it done. But it's been sitting here way too long. So that's what I'm going to do as to the contempt matters.
And the drug test, Your Honor?
What I'm looking at in the file is that the drug test was done on September 28, 23, or filed on September 28, 23. It shows all negative. That's of Erica Turner. There's another one that was filed. I don't know if it's the same one, actually. I didn't compare them. That was filed on August 13, but it was actually done in September of 23.
I believe that the court ordered an evaluation, Your Honor, with collateral input.
So there was also an evaluation, and I think that, let's see, wrong one, just a second. So there was an assessment done. It was filed August 21, but it was done April of 24. The court's not going to find contempt on that. The evaluation was done, but I am going to require that the mother redo the evaluation and that the father be consulted for input in regard to that evaluation.
Thank you, Your Honor.
Thank you, Your Honor.
All right, so that brings us to, so these are kind of mixed up a little bit in regard to a couple of these things. There needs to be some clarifications. One is about not traveling out of state because of the conflicting language that's in the prior order. That needs to be clarified. And so for all purposes, the court is not going to limit the parties just to the state of Washington, but the court will limit them to Washington and Oregon.
Thank you, Your Honor.
I understand, Your Honor.
All right. So in regard to the motion on the parenting or temporary motion.
Thank you, Your Honor. The motion to modify is being brought because there has been a significant change in the circumstances from when the court entered the order in May. Since then, the guardian ad litem report has come forward. The court did receive it back in September and left open the door for a party to bring a motion that would, I would say, obviously, the father in this case, because the guardian ad litem's report does recommend that the father have custody, primary custody of this little girl, and that the mother have the first, third, and fifth weekends of the month. It would be a reversal. The mother is employed as an Uber driver. She can make the move herself. She can be close to her daughter. She's shown a very easy willingness to move. Your Honor, the conditions which have not been denied by the process servers for the contempt motion, the conditions that this child, the mother and siblings are living in sound horrific, and they're not denied. There's no way around that. This is not a healthy place for my client's daughter, simply put. He has a better home for her. He has a room for her. Accountability. We are asking the court at this time to change the decision-making because of the poor judgment that the mother has shown here, certainly in this most recent living condition. Your Honor, the guardian ad litem's report on page 12 does indicate some very alarming language. And because it's not part of the public record, I don't want to go into it. The court has indicated that the court has reviewed it all. But it's just very concerning. I've been practicing law for many, many decades. And this report is just very alarming in how the guardian ad litem reports what the child is saying. It's also not denied that the child is not seeking or having medical or dental care provided here, Your Honor. That's not denied. It's simply not happening. The little girl shows up to my client's time, and according to my client, she feels embarrassed. He senses that. The guardian ad litem report is very clear that both parents truly love this little girl, and that she's very lucky. But it's very sad that the mother has some limitations here, Your Honor, and it appears to have gone on for several decades with her as well. There are other children that she's had. There have been similar problems that the mother does tend to move around a lot, deny care. There's been some assaults. Your Honor, the school year is about to start, and now would be a very good time for the daughter to get used to the new school. It's the pictures that we submitted. She looks quite delightful. I'm sure she's going to have no problem making friends in a new school. Nobody has raised concerns that her friendships are so tight that she's going to suffer any undue harm here. Your Honor, we're asking the court to modify the primary residential care in putting the child with my client. And I'm just looking through. Oh, we are asking also that the exchanges change. This showed up it's in our temporary parenting plan, that the exchanges take place in Natchez, Washington, just for closer to midway between the parties. And again, I'm going to go page 12 of the GAO report, just has some very endearing language about how this little girl spoke to the GAL about how her parents, how she converses with her parents and how they converse with her. I'm just Again, Your Honor, I would point out that my clients have fulfilled all of the GAL's recommendations. We submitted those reports, and the mother has not denied the filthy conditions and the unhealthy hygiene that this little girl is exhibiting. Thank you very much, Your Honor.
Mr. Trotter?
Yes, so just out of the gate, addressing the concerns about uncleanliness and filthiness. It's my understanding that Child Protective Services has been to my client's residence on numerous occasions to assess the family environment.
Objection, Your Honor. This is not in the record.
Mr. Trotter?
So concerning filthy, again, it's baseless at this point. So at minimum, it's baseless. And again, even if a person's home was filthy at some time, I think we could all, at least I can say that my home has been filthy at the time, but not necessarily damaging to the health and well-being of the children. Also, I want to address the issue concerning the mother's employment, driving for Uber. I think the assertion has been made, or the inference, that is not a real job. That is a job for many Americans and many individuals across the world. So I object to that characterization of my client's employment. There are no changes in circumstance, whether they be substantial or non-substantial changes. In my opinion, based on the statute, there'd be no reason to change the parenting plan. The court even ordered the current parenting plan when it did in May of 2023. The children are well provided for. Even the other children she's provided for, and some adult children, they've gone on to do wonderful things, despite them living in this claimed filthy environment. So to address the medical and dental care, again, there's really no factual basis for that. And the assertion that my client has poor judgment, I'm not sure where that's coming from either. And then I'll just defer to the court on, any changes to the parenting plan with respect to the exchanges that Mr. Anderson refers to.
Ms. Corey?
I'm sorry?
I'm the guardian ad litem.
Oh, sorry, thank you.
Sorry, I'm on a different device than I usually am. It's been quite some time since I filed my report. While the attorneys have submitted documents to me, other than that, I have not followed this since the time that my report was submitted. If there were some specific questions, I would be able to answer those. But other than that, I stand by my report. What I do recall most is that my recommendations were based on the overall stability that each parent was able to offer for this child at the time of that report. And as I said, it's been almost a year, I believe, since I submitted that. So that's all I have. Thank you.
Mr. Anderson? Thank you. Mr. Anderson?
Thank you, Your Honor. As far as going to the filthy conditions, Your Honor, those are not baseless. There were 2 eyewitnesses to it, and then the reports of what was said when they got in the car, of how disgusted they were with what they had just been through. And if my comments about employment indicate that that's not a real job, that's the last thing I wanted to say. But what I do mean to say, working for Uber, I believe that that's rather a movable job, literally, and that the mother would be able to do that in another place. If she's a good driver, she should be able to do that closer to the child. She can move with the child. And perhaps, Your Honor, as with her other children, some were given to the father. Hopefully the mother, from having more free time, will be able to focus on taking care of what appears to be an alcohol or some mental health issues. And I do strongly disagree. We do have a change in circumstance the court did not have back in May, and the court did have it in October. The court permitted us to come back, and that's exactly why we're here. Finally, Your Honor, I agree with the court. It's time for this case to get to trial, but right now we do need to take care of this little girl and put her in a safer, more stable environment. Thank you, Your Honor.
So here's what I'm going to do at this time. A recommendation of a guardian ad litem is just that, a recommendation. And as I said, the matter needs to get set for trial. It's been out there for some time. And to, you know, I understand there are allegations, but to say that there are significant changes to a point where there was a ruling last year that denied any changes. And so at this time, I'm denying any changes with the exception or except for I do want Ms. Corey to get back involved. My concern is it goes to trial and we do not have fresh information from Ms. Corey as to where things are at this time. It's just sat here way too long. And so I'm going to reappoint Ms. Corey to look at things and update a report. And I didn't look to see what the original order was as far as payment, but I don't think there's been any significant changes as far as that part of it. So it'll just be the same percentages and the same as far as who's paying what. So get that going as soon as possible. And I'm not looking for specific reviews except for a final update. Ms. Corey, what are you thinking as far as where you're at with? Okay.
I'm out of town, so I'm on a completely different device. So the one thing that I will want to request is CPS records, as was indicated that has some CPS investigation has happened, and those typically have been taking 45 to 60 days after the request is submitted. I won't be able to submit that request to CPS until I have an order of reappointment. So to be safe, 60 to 70 days out from when that order is entered.
Okay.
And if I may, Your Honor, said one thing, please. There were, just to clarify, they were investigations. They were family assessments. There is a distinction between CPS family assessments and CPS investigations.
Okay. So whatever the CPS records are, get those, and then get those to Ms. Corey. Get that reevaluation of mom with input from dad. Bottom line, I don't want to make changes, go to trial and no changes and have to change a child again. I just don't know. But I think it will be important that Ms. Corey do an update so we see where things are at. And then meanwhile, the court will go ahead and continue to follow the May 2nd, 23 order with the changes that I've talked about. You say the exchanges have been in Natchez?
No, that's what we're asking for, Your Honor, which would be a change. The temporary order, it's over to the side. It's been Packwood, I believe, if I can get a nod from.
Wherever it's been, if it's been Packwood, then that's where it needs to be for now. So, so there will be that change. Also, as I said, parents are limited to Washington and Oregon. There was something else that I had. Then I have the requirement in regard to child in school, the change in the vacation time process, dad by April 1, mother follow with her request by May 1. So those additional changes as well. Meanwhile, the parties need to make contact again with Ms. Corey. So anything else, counsel, that you can think of, Mr. Anderson?
I'm sorry, I'm unclear. Where will the exchanges be taking place?
Packwood.
Packwood. Thank you, Anna.
Okay. All right, so this is still temporary. Unfortunately, while Ms. Corey's doing her report, you can try to get something after, let's say in January, for trial purposes, and hopefully Ms. Corey can get her report updated by then. So if you want to note it for universal trial setting, and get a date starting in January, that'd be good. Needs to get in front of the court.
Thank you, Your Honor. Will do.
Thank you, Your Honor. Thanks, counsel.
Thank you.
All right.
Thank you, Ms. Corey.
You want to set it on for a presentation next Tuesday?
Check here. Yeah, that'll work. This will be appearing for this court as well. That's
Okay.
the third, right?
Right,
Yes, third.
September 3.
Yes, I can do the third, Your Honor, from
Okay.
counsel.
All right, I'll have presentation on that day.
Thank you, Your Honor.
All right, thank
Thank you,
you.
Honor.
Thank you, Your Honor.
All right, that concludes this matter.